When South Dakotans need reliable information, SDPB is there providing updates and coverage that keep our communities safe and connected. Good, useful, and full of wonder. SDPB. SDPB celebrates South Dakota's student athletes with live coverage of SDHSAA state championships, sharing the excitement of hometown heroes. SDPB. Good, useful, and full of wonder.
All right, we are in Senate Judiciary. It is February 17th, 2026. I'm going to call the meeting to order. Welcome, everyone. Welcome our listeners online. Remember that cell phones should be off, so no disruptions. If you'd like to testify in person, please use the sign-in sheet in the back or scan the QR code. And then we do have a number of online testifiers that are out there waiting for us. With that, I'll ask the secretary to call the roll.
Senator Blanc.
Here.
Duhamel.
Here.
Grove.
Here.
Milhoff.
Here.
Pischke.
Here.
Hulse.
Here.
Colbeck.
Here.
Mr. Chairman, we have a quorum.
Excellent, thank you. With that, we do have some minutes out there. I'll look for a motion to approve the minutes from our previous meeting.
Second.
Motion by Duhamel, second by Hulse. Any discussion on your motion? If not, all in favor say aye. Aye. Opposed, nay. Thank you, the minutes are approved. Reminder to testifiers to sign in and ensure your lobbyists, if you're in the room, make sure your badges are showing. With that, we'll introduce our pages quickly. Catch you before you leave the room. 2 seconds. Who are you? Where are you from? Where are you going?
I am Esther Burkhalter. I'm from Prairie City, South Dakota, and I'm going to attend SDSU for a business degree.
Nice.
Hi, I'm Ada Ryder. I go to the Henry School District, and I think my future plans are to go to SDSU and major in aviation.
Oh, wow. Thank you. Good. Excellent. All right. With that, we have no personal privileges. Just a reminder to all testifiers that all questions will be addressed through the chair. With that, we're going to move to our consideration of bills. Senate Bill 159 is at the top of our agenda, but we're going to move that to the bottom. So what we're going to do is we're going to start with Senate Bill 162, then 163, then 224. If we can get those in, we'll move to 159. If not, 159 will be heard on Thursday. Is that okay,
Mr. Chair, I was hoping we could do 224 first, and then 162 and 163.
Any objections to that? If not, that's how we'll proceed. So we'll do Senate Bill 264, provide a rebuttal presumption in favor of joint physical custody of a minor child. Then we'll go to 162, Senate Bill 162, then Senate Bill 163, and if time, we'll hear Senate Bill 159. With that proponent testimony, we're going to go 20 and 20 on pros and cons, and then we'll go to commission discussion, and then questions and discussion and action. Senator Pischke.
Thank you, Mr. Chairman, and members of the committee. As you know, my name is Senator Tom Pischke, come from District 25, Dell Rapids. I'm not going to give you a long belabored introduction. I have lots of people here that also want to talk on this bill. This is very similar to the shared parenting bill that I brought last year, and so I think you guys are all well versed on what I have to say about that. So with that, I'm just going to kick it off to other people and let them have a say. Thank you, Mr. Chair.
Sounds good. Any other proponents in the room? Proponents in the room. Okay, there we go.
They're out of the room now.
I'll be a page if that's okay.
Yeah. They both left the room. So. Sounds good. We'll just have you turn your mic on.
Yes.
And then introduce yourself.
Zach
you're
Martin,
from? We'll go from
Rapid
there.
City, South Dakota.
Sounds good. All right, go ahead.
Okay, thank you. Chairman, members of the committee, thank you for this time today. There's a chance to hear this bill, and I spoke last year, and I printed out some slides, and I'll kind of go over them, but I will also talk from the heart. I was just a little nervous. One of the things that came up last year was a lot of anecdotal comments about things I've seen in my practice, things that my law professor told me 40 years ago that, you know, I take as gold as being what the standard is forever going forward. And the reality is that since law school 40 years ago, there's been a lot of things that have happened and a lot of evidence that's been done and a lot of work that's been done to show that what kids need is two loving parents and the least amount of fighting possible so they can have healthy and happy and connected relationships with their kids and with their parents, because kids want to love and be loved by both families without a lot of fighting and a lot of drama. And the current system we have right now with the National Parents Organization, they've rated us an F+, which There could be worse, I guess, but it's at the bottom of the barrel. And we have the opportunity here today with this bill to move this forward significantly with giving kids access to both moms and dads without a huge fight, without a giant cliff and a need to fight over who gets to be in charge of kids and who gets to be relegated to a weekend warrior and the fun weekend parent who doesn't get to have any real say-so and any significant impact in their kids' lives. And more importantly for the kids, that impact of having that parent show them their style of doing things and how they do it and getting to learn and see that this other parent also loves and cares about them as much as the other parent. There's been some work that's been talked about, and one of the things to say is that, high conflicts can't work. High conflicts don't work. And a lot of promoting the status quo. What we have here is working great, and we don't need to do anything different than what we have here. But what we have here is not working great. And I talk to dads across the state daily, and I work with dads all the time who are going through really hard times trying to be involved in their kids' lives, trying to spend time with their kids and be connected. And so we have a real problem with these being done. And one of the big claims that they say is that there's this high conflict fear that we have this presumption and believe that there's this presumption to not having shared parenting, and that if there's a presumption that they can, somebody's going to do something bad. And we all have a bunch of laws. I think you guys write laws every year, every day, and somebody breaks them all the time. And we have penalties for people who don't do and don't follow the laws. And that's why there is this penalty. There's a rebuttal, which gives a judge the opportunity. If somebody doesn't do things the right way, if they're not fit and loving, a judge has the obligation and the right within this bill to actually go out there and do something about that parent who's not doing it. So the fear that high conflict can't work is mitigated by that. And these parents who are in high conflict, it's been shown through evidence that these guys actually do better when we take away the fight. That there is no fight now for parenting. There is no fight to be in the kids' lives. We've removed that. And so when you remove that, you don't make it a winner take all, that you get to be a parent because you're a parent, and as long as you're not unfit, on drugs, an abuser, things along those lines, that you're fit to be there. If you live 15 hours away, obviously that's too far, right? But that all those things give the judges that discretion to make those choices, and that's where the rebuttable part comes in. And they talk about how, like, you'll hear that they talked about last year and the year before that infants need single home base, kids need single home bases, but kids do better when they have both their parents. The science shows if you have both your parents, you do better. And Warshak proved that, and they have 110 studies that show that that's the facts. And my son loves being with me, and I talk to all these guys who their kids absolutely love being with their moms and their dads, and they come running to them and jump into their arms, and these guys want to be there and want to show up for their kids all the time. And then they're going through this fight to be able to be there. There's a whole bunch of evidence inside of here. I print off all the slides. You guys can look at them. But they really talk about the idea that what we have here is a system that puts parents against each other for the control of their kids. And these are already people who are going through a breakup. They're already going through a hard time. People are angry. There's a high emotions. There's high tension. And these people are sad and they want to just be mostly just be parents. And most of these people that say that they just want to be parents want to genuinely be parents. But then we make it this astronomical task to go through this process of fighting to be there. And one parent takes the kids, and then it just becomes this tit for tat combative thing till you get through court to then get that case to be heard. And so, they'll claim this is a cookie-cutter approach. But what we have right now is a cookie-cutter approach where the person who takes the kids gets control until you can prove that yourself is capable or worthy of that time. And what we see in the courts, and I could give you guys stats if you want, but the stats say that the courts don't change from the temporary orders. The temporary orders are what they put out with, and they mostly go with those temporary orders in the end. And so people want to fight because they want to be a mom and they want to be a dad. And then the reality is that what they start out with is what they usually end up getting. And so these parents, and myself included, like I want to be my son's dad all the time. And I've gone to court a couple of times to get to see him and get to be with him more. And I thank Tom Pischke for getting me to have Wednesdays, because I wouldn't even get to see my son if I didn't have Wednesdays right now. The way the schedule sets up, I would have seen him Christmas break, and then I would have had him for 1 weekend in January and 1 weekend in February, and that's it. And my son needs to spend more time with me than 1 weekend a month when it's the holiday weekends that she gets. He needs more time. I have value and things to impart to him and to coach him and to support him in growing up. And I want to be there for those moments to help him when he loses his tooth, to help him when he's needing some help with his homework. I got to do his Valentine's Day project with him. We made a Fortnite fort, and it was fun. And most parents want to do those things. They want to be there for their kids. And I know we got a lot of people who want to talk in favor of this stuff. I may get a chance to talk at the end, and if I do, I'll answer all the questions you guys have. But I know that the kids will do better when they have a chance to have both parents. So thank you.
Excellent, thank you. With that, we'll go to any more proponents in the room. Proponents in the room. All right, we'll just have you say your name, where you're from, and we're at about 7 minutes here. We're going to 20.
Good morning. Good morning. My name's Shane O'Connor. I'm a business owner from Burbank, South Dakota. But more importantly, I'm a father who has witnessed firsthand how our current system is failing our kids. I stand before you as a proud Marine who has served my country in Iraq, defending the very freedoms we hold dear. Yet, when I returned home, I found myself fighting a different kind of battle, one that shouldn't exist in the first place. After my military experience, I faced an expensive, emotionally devastating fight simply for the equal opportunity to raise my own children. This wasn't just my story. It's happening to countless families across South Dakota right now. Our current system forces one parent into a secondary role, creating unnecessary conflict and robbing children of the love and guidance they deserve from both parents. Senate Bill 224 promotes shared parenting, ensuring that both parents remain actively involved in their children's lives. This balanced approach not only supports healthy development for our children, but also prevents families from diverting critical resources, such as funds earmarked for their college savings, into prolonged legal conflicts. Moreover, consider the overwhelming consensus in the parenting community every year. Approximately 12,000 parenting books, 27,000 parenting studies are conducted, and 11 million blog posts are written on the subject. Yet not one of these sources advocates for depriving a child of the love and support of one of their parents. It's time for South Dakota to join the movement toward a more equitable, child-centered system. I urge you to support SB 224 so that our laws reflect what's best for our children and ensure they can see both parents can contribute equally to their upbringing. Thank you.
Thank you, Shane. Any more proponents in the room?
Hi, I'm Nicholas Toth out of Rapid City. I am also a veteran. I did 2 tours in Iraq and a tour in Afghanistan, and I have the same kind of experience. War is tough. It's hard on you, hard mentally, physically, but coming home and having to fight a government, a legal system that is supposed to be designed to protect you and the people, being used against you at every turn possible. My retirement is gone. My kids' college funds is gone, all because of a system that is allowing a adversarial aspect versus a kid-first aspect. I grew up without a father because of the same system, and so as a kid without a father, I struggled. I didn't get the same hunting, fishing experiences. I don't have the same fatherly roles model that I'm trying to provide for my kids. I'm in several advocacy groups, and one of the biggest claims is that it costs too much to be a dad. And my cost is estimated around $150,000 and growing just to try to be a father. If I don't spend the money, which I've ran out of money, but if I don't spend the money, I lose my kids. So I have to spend the money, but it shouldn't be. It should be just the default 50-50, unless, like they said, there's a reason. If you are abusive, and there's criminal actions already involved or in place for that. By removing the fight, removing the battle, removing the funds, if there isn't a need to win, there's no need to fight. The kids win, but with 50-50. Only the parents win technically by fighting. And only one of them wins. Just as an example, with both me and my ex involved, my kids were involved in sports. They were active, they had friends. Primarily, I feel like that was from me, but then 6 months ago, I was removed. My kids have gained a lot of weight. They've lost a lot of social friends. Their behavioral issues at school. And the only thing that's different is I'm no longer in their lives half the time. I guess I'm just kind of wanting to emphasize that the importance of both parents is critical for our kids. The money shouldn't be an issue. The government shouldn't be an issue. It needs to be about our kids. And I believe 50-50 is the best step forward right now to start the ball rolling. Thank you.
Excellent, thank you. Any other proponents in the room? If not, we're going to turn to our online testifiers. We have quite a few. How about we go to Mr. Reitzman? Are you there? Do we have Spencer Reitzman on the line? If not, who's this gentleman? Mr. Northcutt?
Yes, I'm here. Can you hear me? I'm here. Can you hear me? Good morning.
And you are a proponent?
I am.
Yes, go ahead. We're at about 12 minutes. We're going to 20, so just introduce yourself. Where you're from?
My name's
Tell us your story.
Michael Northcutt. I'm from Rapid City. I appreciate the opportunity to speak. I'm just going to give a brief glimpse into my story. I'm a father of 2 daughters. I was married in 2002, and after a difficult divorce that lasted from 2019 through 2022, and custodies that are still enduring to this day, my relationship with my daughters has been drastically altered. On August 29th, 2020, I lost access to both my girls. Since then, I've experienced what several professionals that testified to as parental alienation. It's a process where the children's relationship with one parent is normal, but after divorce or during divorce is damaged severely through influence, conflict, and prolonged court involvement. Before the divorce, my daughters and I had a close, loving, and consistent relationship. I was actively involved in their daily lives with school activities, bedtime routines, family traditions. There was trust and there was connection. And the truth was, I actually really enjoyed being a dad. I had always wanted to be a dad since I was pretty young, and I was intentional in my practices and my parenting with them. However, during the divorce process, temporary orders, extended litigation, manipulation, and abuse of laws created an environment where my time with my children became restricted and conditional. Over time, distance became normal and communication, it became non-existent. The bond that once felt like it was unbreakable didn't just become distant or fragile, it was completely severed. After being separated from my children for nearly a year, the court had ordered reconciliation counseling for me and my children. However, their mother, Megan Northcutt, would not comply. After a year of no contact, I was granted permission to go to all school events, be at the house, do yard work, work in my workshop. And even though it pained me every single time when I would go to these things and be able to see them, but not be able to communicate with them, it went against my beliefs, my rights, but I stayed faithful and I followed the restrictions that were placed on me. I never made eye contact and I never even made gestures. Still, several false allegations were filed, including criminal charges, even one for an alleged hand wave that never happened, while the no contact was in order. I was legally hit with civil, criminal, multiple charges and had to fight these off. And it created a web that Pennington County Court and the Sheriff's Office could not untangle. Essentially, the left hand didn't know what the right hand was doing. After several more court hearings, Megan Northcutt finally brought our youngest daughter, Macy Northcutt, to counseling. After dealing with dozens of these court hearings and with two licensed counselors who frequently have been used in the court system. Both of them testified under oath that Megan Northcutt was mentally and emotionally abusing our children.
Okay, sir, I'm gonna stop you there. We're gonna bring it back to the bill, and we're on some timed. So we've only got about 4 minutes left. So we understand your story, and I want to be sympathetic to that, but I just need to have you pinpoint it.
I just respectfully ask that you consider legislation that begins to promote the benefits of equal and balanced involvement with both parents, specifically when that pre-existed before divorce, unless there's clear evidence of harm. Thank you for your time.
Excellent. Thank you, Mr. Northcutt. Any other proponents online? I show a...
Whitney Reed, sir.
Yes.
I'm a proponent for.
Thank you, Whitney.
My name is Whitney Reed. I am an attorney located in Sioux Falls, South Dakota. I am here today as a proponent for Senate Bill 224, specifically because over my time as an attorney and in my personal experience, I've watched good parents lose opportunities with their kid based on our current system. The most recent one involved a very dear friend of mine over the last 2 years, where his child missed over a year of school cumulatively in South Dakota, K through 5, where the mom married a drug dealer, but because mom had primary care of the child, my friend, despite mom testifying that he was an amazing father, got the benefit and he was denied shared parenting. If there had been a presumption up front that the starting point was 50-50, I think that would have evened the playing field so that his child had access to both parents. I've seen it happen in cases prior to this as well, where moms were given a benefit. And I say this as a mom who has 2 children, who's divorced, left an abusive marriage. And so I do have primary custody of my kids, but I see the impact on my kids daily because their dad chooses not to be actively involved. So I would just ask the committee consider passing this bill, sending it to the Senate for vote, and supporting it so that parents have an equal shot at raising their children.
Thank you so much, Ms. Whitney. Any other proponents online? How about Mr. Hubin? Doug Hubin?
Yes. Can you hear me?
Yes. Please state your name, where you're from, and tell us your story. We're at about almost at 20 minutes, but we're going to let it run over. So.
Okay. Thank you, Senator Kobach. My name is Don Hubin. I am a professor emeritus of philosophy at The Ohio State University. I am currently the chair of the National Parents Organization. I will be very brief in my testimony here. I would ask that you read my written testimony, which is research dense, and I want to just hit some of the highlights here. We have now 40 years of research that show that children raised in equal shared parenting arrangements do about as well on every metric of child well-being as children raised in intact families, and they do much better than children raised in sole custody arrangements. That research is as univocal as any research in social science is. We also have research showing benefits for mothers and for fathers because fathers experience depression. You've heard some testimony about that from some fathers who have gone through this. Fathers who are divorced and separated from their children are much more likely to engage in risky behaviors and to die deaths of despair. Mothers do better in shared parenting arrangements because they have more of an opportunity to pursue their career, education, and personal life and so forth. So this is a win-win-win situation. Sometimes people worry about whether it's appropriate in conflict situations, and of course it isn't appropriate when there's family violence. But the mere fact that parents don't agree on everything is no reason not to award shared parenting. Kids do very well even when parents disagree on a variety of factors. The current system, as some people have testified, is actually a cause of conflict between the parents. parents are thrown into a situation where they need to fight in order to maintain their relationship with their children, and that leads them to say bad things about the other parent. In fact, attorneys often encourage them to say everything they can that's bad about the other parent to win in this battle. So the current system actually causes some of this conflict, and we have evidence of that in the effects of presumptions of joint custody on intimate partner violence. In every jurisdiction that has enacted a presumption of shared parenting, we've seen intimate partner violence statistics go down dramatically in some cases. In Spain, there was research done where it dropped by almost 50%. We've also seen that child maltreatment cases go down when children have the active involvement of both parents in them, and I provide evidence of this in the written testimony I have here. The public support for presumptions of equal shared parenting is extraordinarily high in every state. In South Dakota, it is 84% of people support a rebuttable presumption of equal shared parenting. And in these days of a highly polarized political climate, it's rare that you get 84% support for just about anything. And when you dig down into the demographics, this support for presumptions of equal shared parenting cuts across every demographic divide, cuts across political affiliation, race, education, religion, ethnicity, and importantly, gender. Both men and women support presumptions of equal shared parenting. Some people worry that the courts are not going to accept this or like this, but in fact, the follow-up studies in the states that have done enacted presumptions of shared parenting show that this is supported by the majority of judges and other court professionals and the plurality of attorneys. So that's my testimony. I hope that that South Dakota will move from getting an F+ in National Parents Organization grade of shared parenting legislation to join the states like Kentucky, Arkansas, West Virginia, Florida, and Missouri to get an A. Thank you.
Thank you very much. Any other proponents online? I don't think we have any. We had some other folks sign up, but I don't think anybody's there. So we're going to stop proponent testimony. Check one more time in case anybody walked in for proponents, made the trip here. If not, we're going to switch to opponents. Senate Bill 224. Opponents in the room, and then we'll go to online opponents. We're going to start the clock. We went about 23 minutes, so I'm going to reset it. We're going to start the clock and give you the same time.
Good morning, Mr. Chair and committee members. Melissa McCauley, registered lobby for South Dakota Network Against Family Violence and Sexual Assault, otherwise known as the Network. I thank you for your time and to speak on this. Senate Bill 224 creates rebuttable presumption that joint physical custody, meaning roughly equal parenting time, is in the child's best interests. It also repeals current law and clearly states that there is no presumption, and the court decided custody based on the individual best interests of the child. This is a significant shift. On paper, a presumption sounds neutral. In real life, especially in families impacted by domestic violence and sexual assault, it is not. A rebuttable presumption changes the starting point. Instead of beginning with full individualized safety analysis, the court begins with an equal time frame. That means that the productive parent must prove why the default is not working. In many abuse cases, there's no criminal conviction, there's no protection order, and the abuse is often coercive, controlling, financial, or psychologically. It does not always show up neatly on a nice little police report. Children should not have to wait for a felony conviction before their safety is prioritized. Equal physical custody requires frequent exchanges, ongoing communication, and continued coordination. In high-risk cases, that can create more opportunities for intimidation, manipulation, and using children as leverage. Post-separation abuse is real abuse. Our advocates see it every day, and we have in 66 counties, 72 organizations. This bill also risks increasing litigation. When the law sets the presumption, parents fight over overcoming it. That costs money, time, and often benefits the party with the more resources, not the child. South Dakota current law allows judges to award joint custody when it is appropriate. It simply does not force a starting assumption. Senate Bill 224 removes that safeguard. Custody should not begin with that formula. It should begin with safety, stability, and real needs of the child in front of the court. And I do want to say that there are some states right now, joint custody in only 2 states, Colorado and Nevada. Joint custody in the best interest, so states that presume joint custody unless any other offenses from the list of conditions occurred. There's Alabama, Arkansas, Iowa, Missouri, New Jersey, New Mexico, Utah, West Virginia, and Wisconsin. But the states that follow are, we have Alaska, Arizona, California, Connecticut, Delaware, District of Columbia, Florida, Georgia, Hawaii, Idaho, Illinois, Indiana, Kansas, Kentucky, Louisiana, Maine, Maryland, Massachusetts, Michigan, Minnesota, Mississippi, Montana, Nebraska, New Hampshire, New York, North Carolina, North Dakota, Ohio, Oklahoma, Oregon, Pennsylvania, Rhode Island, South Carolina, Tennessee, Texas, Vermont, Virginia, Washington, and Wyoming. I state those because clearly this is working, and we are wanting to do what is best for the child. And with that, I ask you to oppose this bill.
Thank you very much. Any other opponents in the room?
Good morning, Mr. Chair, members of the committee. I'm Steve Siegel, and I'm the registered lobbyist for the South Dakota Trial Lawyers Association. We, too, rise against Senate Bill 224 this morning. I'd like to say, first of all, I think this is the 10th year that Senator Pischke and I have locked horns on this issue, and I do tip my cap to him for coming back every year, and also the guys that came to testify today. I don't pretend to know what these guys have gone through. I have 3 adult children, and I never had to deal with this, so I don't sit up here trying to pretend that I know what it's like to be in this situation, because I don't. But we want to look at the best interests of the child, ladies and gentlemen, not the best interests of mom and dad. And that's what the trial lawyers, the problem that we have with this bill, is that it looks at what's best for mom and dad, or mom or dad, not what's best for the child. You should start and end with the child. And we believe this law is unnecessary because the circuit judges in South Dakota already try to do this. They strive to do this, and there's always good reasons if they don't. So in the cases where it's appropriate, the judges look to award joint physical custody. In cases where it's not, they don't. So there's always a good reason when it's not done. And we believe it should be done on a case-by-case determination, and that a rebuttable presumption is not a good idea, because you should look at every case on an individualized case-by-case basis. You might have an infant child that's breastfeeding. You might have a special needs child. It might be just an infant. It might be a child that's nonverbal, but every situation is different, and the court is trained to look at those situations, listen to the testimony of the witnesses, and make a decision. The circuit court judges in South Dakota do a really good job. We were lucky to have really good circuit court judges here. They're trained to do this. Let's let them do their job, and I ask you to please vote red on this. Thank you very much.
Thank you. Opponents in the room?
Good morning, Mr. Chair, members of the committee. Ellie Bailey. I'm a registered lobbyist for the South Dakota Advocacy Network for Women. I think maybe it's appropriate to start where we agree. And that is, the proponents talked about that kids want to be loved by 2 parents. I agree with that, absolutely. And so I think that's an important starting point. I think the disagreement really boils down to what the previous speaker said, is whose interest should come first. And, I think that the key provision, if you look at page 2 of the bill, lines 2 and 3, this is the portion of our law that we are taking out. The court shall determine the appropriate physical care, custody, and control of a minor child based on a determination of the best interests of the child. That is what we would be taking out of the law in this bill. And so, really the primary point that I want to make is that from our perspective, the best interest of the child should remain paramount, that is the law today. And, we want you to please think about, how appropriate it is to take that out of the law. I think also South Dakota law is very clear. There's a wide body of case law. The South Dakota Supreme Court, as recently as 2024, has reiterated the following: permeating our more typical custody and visitation decisions is the unremitting principle that our brightest beacon remains the best interest of the child in all judicial decisions concerning a child's care. And the court goes on to say the primary focus is the best interest of the children. And so, by taking that out of the law, as the previous speaker identified, it's not always then what's in the best interest of the child. It can be a consideration of what's best for the parents, and that's not always appropriate. I would also share current South Dakota law, SDCL 25-4A-24, which outlines factors for consideration of request for joint physical custody. These are the clear guidelines that circuit court judges look at to determine whether joint physical custody is indeed appropriate. There are 23 subpoints considered there. And so these are very, I think for those of us that have kids, we know that no child is the same, right? No fact set is the same, no parent is the same, and no child is the same. And that's why under our law, there's really case-specific analysis in the court applying the specific facts and how these factors align with that. And so we'd ask that you, keep the best interests of the child as the bright beacon, which is already South Dakota law today, and oppose this bill. Thank you.
Thank you. More opponents in the room? Opponents in the room? If not, we're going to go to opponents online. I know there was a ma'am from Redfield. Casket. I'm going to slaughter your last name. Kristen, are you there? No? You might be on mute.
Can you hear me?
There you are. Yes.
Thank you, sir. So my name is Kristen Kochekian. I am a family law attorney in Redfield. I have been practicing in South Dakota with family law as a primary specialty for the past 10 years. I agree with what the opponents have verbalized already. I do agree that it's shifting the analytical starting point from what's in the best interest of the child to why should we not order 50-50. Generally, I see a lot of low-income parents and domestic violence victims that lack the ability to afford an attorney. And the reason why that's so critical at the initial determination stage is because they need to be able to put on witnesses and evidence and make clear arguments to the court as to what's in the best interest of the child. The current framework allows those individuals as the primary caregiver, the people that are handling the day-to-day school enrollment and the medical care and the routines and the activities already, to remain in the child's life and to not disrupt that child's routine, which is critical, especially in the event of a family breakup. So there is often an established primary caregiver, and then the current framework allows that caregiver to remain in its role, and then the non-custodial parent can always come back and make an argument as to why they would be able to provide a safe and loving and healthy environment for the child. As the prior opponent had noted, we are removing the best interest of the child framework, and we are moving to a 50-50 presumption, which is displacing that established caregiver structure It's forcing a rapid restructuring of the child's routine, and it's prioritizing symmetry over stability, which leads me to my most important point, really, is that we are presuming that co-parenting in a healthy way exists in every family, and unfortunately, that's just not the case. The bill presumes that equal parenting time without first requiring that the parents can effectively communicate, that they can make joint decisions, that there's sufficient geographic proximity allowing them to have 50-50, and that work schedules permit meaningful exchanges. I represent fathers and mothers and extended family members all the time in these custody determination hearings. And the fact is there's a significant percentage of families in the immediate aftermath of separation that just cannot co-parent in a healthy way. And so the current framework allows for the court to determine what is in the child's best interest at that given point in time, which can always be modified in the future. But it allows the court to make a determination for each family in each case where the facts are different in every single case. A presumption does not create cooperation. Instead, it may institutionalize conflict. And so I do see healthy co-parenting situations where the parents come together and say from the start 50-50 works. But when that co-parenting doesn't exist, you're placing the children in a position of chaos from the beginning, which is not in the best interest of the children. And I don't think that the court would support that type of framework either. As a prior opponent noted, you're destabilizing young children, infants, toddlers, children with special needs from the outset. And so you're disrupting perhaps for young children developmental attachment patterns, which are critical to child development. And you also can create instability during a high conflict transition period. And finally, I have a real concern that you're creating vulnerability where parents to abusers or to people that have not been in a healthy relationship would choose to forego child support if the other parent is using that as a bargaining tool to give up 50-50. And so essentially, I want to protect my child from this parent that may not even, not be an abuser necessarily, but not provide a healthy, stable environment for that child. I would be willing to forego financial stability in order to protect my child. And again, that is not in the child's best interest. This is not child-centered policy making. And so I would also say to the proponents that this bill is not going to remove a fight. It's not going to stop any access to the court. It's not going to make your cases necessarily better because ultimately it sounds like in those cases, the court did make a determination on the best interest of the child and made that decision that it made. It's not going to prevent the fight, the litigation, the cost. But what it does do is it allows those primary caregivers that were serving and acting in the best interest of the child initially to do so. And again, modification is always available. So I would say finally, in summation, that no two families are alike. Geography, work schedule, developmental stages, parental dynamics, they matter. Our current law allows judges to weigh those factors neutrally. This bill substitutes legislative preference for individualized judicial discretion, and I would urge you to vote no.
Thank you. Opponents online, I have the ma'am from Yankton, Gilder Pierce. Are you there? Ms. Gilder Pierce?
Yes, I am.
Thank you. Go ahead.
Oops. Sorry about that. Let me get my camera on for some reason. So thank you, Chair and Committee. My name is Taryn Van Gilder Pierce. I am a licensed clinical psychologist in practice for the past 30 years, both in the state of Arkansas and South Dakota. I have worked during these 3 decades in clinical and forensic settings and extensively with child custody evaluation experience, in addition to working with divorcing families. My express concern is with the Senate Bill 224. What I want to begin clearly to indicate is that I am not opposed to shared parenting whatsoever. I have recommended shared parenting many times when the conditions are present for it. I have also recommended primary custody to fathers and mothers relatively equally over the course of my career. My concern is not shared parenting. My concern is a statutory presumption. So what I will direct you to is to read my written testimony, which, similar to a previous individual, indicated that it is research dense. The majority of what I'm speaking about today is research based. And when we look at presumptions, although they are labeled rebuttable, it functions as an anchor. So what it does is it shapes the starting point from what arrangements best serve this particular child to why should we depart from equal time. And that shift is subtle but real, and it is certainly not neutral. It changes how parents litigate, because if equal time is the default, the case has become a contest then over time instead of what is best for the child and what is needed in each circumstance. Again, it's not about the parents and the parents' time, it's about what is best for the child as far as the resource and assets of each parent and what they bring. Now, part of the concern, too, is that literature is consistent that parental conflict is one of the strongest predictors of harm of children post-divorce or separation. Equal time does not necessarily neutralize that conflict, and in some families, it can increase it. In high conflict systems, children are more likely to experience loyalty pressures and chronic stress that clinically shows up in anxiety, sleep, somatic, academic, and behavioral problems. And the presumption doesn't screen for these risks. It assumes the structure first, which would be shared parenting, and then places the burden on the family to prove why it isn't working and it should be different. The other piece that's been alluded to as well as that children are not developmentally interchangeable. There are attachment and developmental science that consistently underscores the importance of stable, predictable caregiving, particularly in early childhood. So these frequent transitions in the context of a high conflict parenting situation can certainly destabilize that process. And that statutory presumption does not distinguish between the developmentally resilient child and conflict-sensitive young child. So the psychological impact certainly is huge in situations where parenting time is assigned or custody is established that is not best suited for the child. What I can indicate is that shared parenting can be beneficial when appropriate, and that is shown in the research. What it suggests is that it is supported when certain conditions are in place. The important qualifier is that children who have parents who have voluntarily entered into shared parenting or have sufficient cooperation to implement it successfully. In other words, the benefit is most consistently associated with family functioning and the emotional climate between parents, and not equal the equal time structure itself. So there are many good fathers and many good mothers out there. They're good, devoted, loving, capable, deeply involved in their children's lives. And I would like to point that a determination of equal shared parenting is not optimal in cases where the finding that the parent is certainly not necessarily unfit or not loving, but maybe not best suited for that child at that particular developmental time. It is the totality of circumstances that creates a situation to determine the best structure. And that is based on the best interest of the child, which should remain in place and override any other supportable suggestion. According to the standards of my profession, the American Psychological Association guidelines, the Association of Family and Conciliatory Courts, both the individualized child-centered evaluation of each circumstance that promotes flexibility and case-specific parenting plans is best supported for the children. And these professional standards do not endorse statutory presumption of equal time. it is in the best interest of all children, subject only to rebuttal. And so that piece is important. I urge you to reject the Senate Bill 224, instead preserving judicial discretion that we currently have. I would like to thank you for your time and considering the psychological well-being of South Dakota's children. I'll gladly take any answers. Any questions?
Thank you. With that, I believe that we're done with opponent testimony online. One more time for opponent in the room. If not, rebuttal from the sponsor.
Chair, I was going to have Zach do rebuttal. Is that okay?
Sure.
Thank you.
We'll give just a few minutes for rebuttal here, and then we'll move to discussion, committee questions.
Thank you, Chair Zach Martin, again today. Thank you for having me. A lot of things that were said. One of the big things that was talked about is best interest of the child. Best interest of the child is of most importance. I mean, we want to have kids having what's right and help them out to be as successful as possible. And it's been proven through the research that's been done that kids who have equal time with both their parents and the more time with both their parents have better outcomes. The kids who have the most problems are the kids who are in single-family homes. Higher risk of child suicide, higher risk of teen pregnancies, higher risk of dropping out of schools, higher risk of bad behaviors, doing drugs, going to jail, doing inappropriate and ineffective things because they have a separated family and they have one parent who's raising them, who's out, not always there. And so kids who have two active and involved parents have a better chance of being success, and the research shows that having both parents is more successful. It reduces violence by having shared parenting. It's been proven in Kentucky in the slides that I gave you guys. They had a nearly 70% reduction in domestic violence cases in Kentucky because of shared parenting being established. And it shows a very clear line that it was flat until 2018, and then it's had a huge reduction. And that reduction is because you're not having people fighting to be a parent to their kids. They don't have to fight. They may have to get along with that person, but they don't have to fight them tooth and nail to be allowed to be the winner take all of rights to the kids. They get to be allowed to be a parent because they are a parent, and their kids get to have their love and their time with each of their parents without a fight. And that's what's been shown to have that stuff. And I think Don Hewen talked about how in Spain they had a 50% reduction in intimate partner violence when they've established shared parenting. And that's the stuff that these domestic violence centers should want. We should want to have a reduction in fights. We shouldn't want to have this winner-take-all kind of fight. And what we do is we have it set up right now that the first person who quits in a relationship and leaves and takes the kids and then holds them, those person wins in our state 90% of the time. We're talking about a 16% of the time chance that you get to have more than a state minimum when it goes in front of a judge, which takes months. The judge doesn't come into this case and you guys split up, and a week later the judge gets to hear you talk about this. The judge is going to come in 6 months later, a year later, 2 years later, and then say, okay, now we get to have a trial and we get to have a hearing. They don't come in 3 weeks after they split up and say, oh, you know what, let's have a whole hearing about this and decide, yeah, we should have parenting. And then it's 2 years down the road. And what did judges say at that point in time? Well, we've already been doing it this way. It's already been going on for 2 whole years. So we can't change it now. And the guys that I talk to that do supervised visits, that's what happens. When these guys talk about how they don't get to see their kids, like Michael Northcutt, and he doesn't get to see his kids. And then when he finally proves himself innocent of the heinous crimes that he was accused of, then they go, oh, well, you haven't seen him in 2 years now. Now we have to have you go slow. So yes, thank you. I got so much stuff written down. I think one of the big things, though, they talked about was that, and high conflict, right? High conflict is exacerbated in these kind of plans. There's more contact with parents who have high conflict than you are in shared parenting. You can easily make a shared parenting plan or a parallel parenting plan, which means the same thing, where you can drop the kid off at school on Monday, pick them up the next week after school on Monday. And then you don't even have to have that interaction with the other parent, or drop them off at school on Friday morning and pick them up on Friday after school. And there's no interaction except for doctor appointments if you do that, and sports. And so it removes so much more interaction and connectivity by having shared parenting. And I could go on and on. You guys aren't going to give me like 4 hours, but maybe one day I'll do a dissertation for it. Thank you, guys. I appreciate it.
Good. Thank you. With that, we're going to close public testimony, and we're going to move on to committee questions. Committee questions. Anyone? No questions?
Mr. Chair.
Senator Grove.
I have a question for the attorney that was just there, I guess. Are you an attorney?
Me?
Yeah.
No, I'm not.
Oh, okay.
I think I lost it.
You slept at a Holiday Inn last night. I have a question for you.
A little bit in Holiday Inn, but not that. Yes.
Mr. Chair. Thank you for testifying today.
Thank you.
And I know that it wasn't easy. I know
No.
that there's a lot of emotion there, and I feel it too. So you have in your PowerPoint the Kentucky data,
Yes.
which is incredible. The 37% drop. All of this is really good information. My question is what do we do with the other states like California, for example, who did have very strict shared parenting laws, and they had a massive increase in litigation, high conflict litigation, they call it, to such a degree that they reversed course and went back, way back to South Dakota laws where it's best interests of the child. So how do we, if we're just gonna look at one state, then we should probably look at California, who has the exact opposite situation. Like, what do you say to those where this is not working?
You know, I had
Sorry,
not.
sir.
Excuse me.
This is just kind of a quirk of our committees, but please state your name and where you're from.
Oh, yes, yes.
Just so we know who's talking on
Thank
the
you.
online
Yeah,
testifier.
Zach Martin, Rapid City, South Dakota. I am not aware of California having a shared parenting standard. As far as I know, they've never had a shared parenting standard since maybe in like 1969. And they changed that probably with no-fault divorce. But that every state that's done it since Kentucky did it in 2018, which is the very first one. I think the lawyer talked about how all these states have the old antiquated style that we have here. And the new states and all the research is showing that all the states that are now going to shared parenting have reductions of domestic violence, have higher quality of standards for the kids and more success. And we're having better outcomes for our families and less fighting.
Question that
Oh, somebody needs to mute.
I was like, what? Am I missing somebody? That they're having much better results in those states. And I would definitely do some research because my understanding is that California has never been a shared parenting state, that they have some kind of rules about it, but it's not shared parenting in per se, that you start off when you split up regardless with shared parenting and then you prove one point or the other.
Thank you. Mr. Chair, can I have a follow-up question, but with, I don't know how to say her last name, so Kristen, the attorney?
Yes, from Redfield. I believe.
Redfield.
Yes.
Thank you. How do we answer this question? Because in California, they did have a strict shared parenting law that caused mass chaos within their judicial system with a high increase of conflict litigation. But there is this 2018 data that comes from Kentucky where there has been a drop. Like how do we weigh this as decision makers over SB 244? What would you say?
Well, so I don't have that data in front of me. I might defer to Dr. Gilder Pierce, who might have more information on that data and statistics. I would say that you likely are looking at a high surge in litigation because, again, I think that this bill is going to take the best interest of the child presumption out from that initial determination. And so you're going to see parents running to the steps of the courthouse trying to make sure that their child's best interest and then each of their family parameters are looked at by the court to make sure that those children are protected. And I also would disagree with the gentleman that is a proponent that said that these emergency hearings aren't possible and it could take 2 years to get to the courthouse steps. That's just not true. You can have emergency hearings. And so what you're going to see is a surge in these emergency hearings for the people that can afford access to legal services. My concern is the people that can't afford attorneys also. So what you're also going to see is a population of people that are going to be underserved by access to legal care in rural communities, and that are also not financially stable enough to spend money on attorneys, that are going to have children that are going to suffer the consequences. And those children are the ones that I'm primarily concerned about right now with your low income families. But yes, I do agree that there will likely be a large surge in emergency hearings, because people are going to be trying to have implementation of what we're essentially taking away from them, which is the best interest of the child standard.
Okay, thank you. And Senator, did you get your question answered?
I did.
Okay. Thank you. Any other questions?
Mr. Chair.
Senator Blanc.
I have a question for Ms. McCauley. You know, as a product of a divorced family, I can verify that I would have loved to have both parents involved in my life equally. Thank you for being here. You had said that this bill represents a significant shift. Can you tell me how long the existing law has preferenced the mom?
Thank you, Mr. Chair and committee members. Melissa McCauley, registered lobbyist for the network. I don't want to pretend that I know the exact date of that.
Okay.
Also, I could phone a friend and ask if maybe one of the attorneys in the room would know exactly how long that law has been in place. Also, as a product of divorced parents as well, so I understand that as well for you. Could we see if Mr. Siegel can answer that?
While you're there, I have a couple other questions.
Yep.
And you might want to phone a friend for them as well. Can you tell me why it's not in the best interest of the child to not have both parents equally involved in their life?
Mr. Chair, Melissa McCauley, the network. I think when you say, can you tell me why it's not in the best interest of the child, I do think that shared parenting can be, but this is not a one situation fits all. We need to make sure that our judges have all the information in front of them for each individual case. I would say in some, the gentleman for the proponent that spoke about reduction in reporting doesn't necessarily mean that abuse isn't happening. What happens a lot of times in these cases is that the domestic violence or the survivor, the victim, is afraid to report because of the fact that this could be used as a weapon against them.
Mr. Chair, one more question, please.
Yes.
Does the rebuttable presumption addition to the codified law remove the judge's discretion and ability to look at each case individually, including maybe even allegations of domestic violence?
Mr. Chair, Melissa McCauley,
Because that was
network.
brought up quite often.
So what it does is it puts it right at 50-50, and it says to tells the judge that it needs to go directly to that without looking at the best interest of the child right away.
And my question,
Sorry.
Mr. Chair, and my question is, it doesn't remove the judge's discretion to look at each case individually, correct?
It may not move it immediately, but what it does is it immediately puts the child behind the parents. So with your question, I would say not necessarily, but it puts it at the forefront of the parents versus the child.
Okay, appreciate it. Thank you. That's all.
Okay. Any other questions? If not, we're going to close committee questions, and we're going to go to discussion. Any discussion? Senate Bill 224? If not, we'll move to act. Oh, yes, absolutely.
Thank you, Mr. Chair. I just want to point out a couple things in the bill, and you guys are probably well aware of this, but I just want to say them anyway, I guess. But if you read just read the bill, it does say for eternal determination. And so what that means is that this isn't going to flood the court. This is only for when you go in for that internal determination. Many people who have gone through divorce or gone through their custody determination already, this would not apply to, myself included. So this is only new people that are going through that. So I would just like to put that out there. And also, I want to talk to the domestic violence part of this. If you read lines 15 through 17, the presumption set forth in this section is not applicable if a presumption that joint physical custody is not in the best interest of the child that has been created in accordance with 25-4A-22. If you go to 25-4A-22, you'll actually read that says a finding by the court that a parent has a history of domestic violence abuse or has an assault conviction as defined in 25-4-45-5 creates a rebuttable presumption that joint physical custody is not in the best interest of the child. So I just want to put that out there, like that should reduce all your concerns about domestic violence, assaults, all that sort of thing, because it actually creates a presumption the other way. So I tried to make that language as strong as possible to appease the domestic violence opponents, but fortunately that just doesn't appease them enough. So just wanted to put that out there. So
Thank you. Any other discussion? Otherwise, we'll move to action.
Mr. Chair,
Senator Grove.
I'm just going to share my opinion for what it's worth. He's my friend. He wasn't my friend, but he is my friend now. This has been a long road, and I've been fighting against this for many years, and the reason is because my concern is for the child and the silent parent who is in an abusive situation, whether it's the man or the woman, and the only way out is divorce. And it's sometimes almost impossible to prove in some situations mental and emotional and verbal and all that type of abuse, which sadly, I think it's getting better, but sadly, I think that's been considered a bit of a joke in some situations. And so I am concerned for those situations when you're trying to force two people to now who can't get along, and now we're gonna put them in two separate homes and make kids live out of a suitcase and go here for 5 days and here for however, and then here, and then here, and then here. There's no stability. And California did have shared parenting, and the reason why they went away from it is because of the high conflict litigation and the chaos that it was causing within their judicial system. I think that our law, what happened was they got together several years ago, and they wrote, I don't know, I think there's like a child custody committee that meets every so many years. They got together, they brought all the best of the South Dakotans together, and they said, how do we fix this? How do we deal with this issue? Because we truly have people who have mental health issues, truly have people who are in abusive situations, and then we have these really good parents that just want to parent. And they came up with a law that said, you can have shared parenting if it's in the best interest of the child, or you have these custody things like we have if it's in the best interest of the child. And they put the child first. And I think that it's important that we protect and preserve that. I would say on the other side, I think that we have some judicial breakdowns. I think that we have some judges that are not so good. Sorry, I think we have some not so good judges. And I think that we need to work on that side and say, how do we now shore up the decision-making side? And maybe that equals referees first, judges second. We do that in child support and it works. Maybe we need to do that here as well. That's just my thoughts. Thank you for letting me speak.
Thank you. And we're going to move along to action. Do we have any action?
Mr. Chair, I move to pass.
We have a motion to pass. Senator Hulse, seconded by Senator Pischke. Comments on your action? No comments? With that, Senator, please call, or the Secretary, please call the roll.
Senator Blanc.
Aye.
Duhamel.
No.
Grove.
No.
Melhoff.
No.
Pischke. Hulse.
Aye.
Kolbeck.
Colbeck votes aye.
Mr. Chairman, we have 4 ayes, 3 nays.
With an affirmative vote of the members here, the Senate Bill 224 is declared passed. It'll go to the floor. With that, we'll move on to Senate Bill 162. Revise the factors for considering deviation from a child support obligation schedule. Senator Pischke. We're going to run the same schedule on this, 20 and 20. We have about 3 for, and 3 against as far as I can see who's signed up here, so we'll go from there. Senator Pischke.
Well, thank you, Mr. Chair and members of the committee. Again, Senator Tom Pischke, District 25. I'm hoping this conversation isn't quite as long as the previous one, but we'll see what happens here. This Senate Bill 162 is basically a simple idea. It puts into the factors for deviation when considering child support, the idea that the federal tax child credit would be something that the child support referee would consider. From my research, this is something we actually did prior to 2004, and at 2004, the Child Support Commission decided to take this out. And now, if you are familiar with the Big Beautiful Bill and how that's going to affect child tax credits, the child tax credit is going to be over $2,000 per child. And so if you consider that, just for my situation specifically, I mean, I have 3 children. I have to pay child support for them, which I'm doing, and I don't ever get to claim them on my taxes. And I don't get any deviation in the consideration when child support is calculated for them. So I think that this is something that we should consider bringing back, and I guess I would just leave it at that. I'll stand by for questions, and we'll just go from there. But one thing I guess I wanted to add is that with the Big Beautiful Bill, the child tax credit is actually tied to inflation now. So now that's like $2,100, it's actually going to continue to go up and up. So it's getting to be a bigger and bigger thing. So thank you.
Thank you. Any other proponents in the room? Mr. Martin? Have you say your name, where you're from?
Zach Martin, Rapid City, South Dakota. Thank you, Chairman and committee, for letting me talk. I probably should have read my notes last time. I'm going to read them this time. We often talk about family values in this chamber. Today, we're talking about family math. So we all share a unified goal. We want children in South Dakota to be supported, loved, and provided for, but we have a blind spot when it comes to the mathematical blind spot that is unintentionally hurting the children we're trying to protect. I did present some slides and stuff, so I don't have them in front of me, but maybe I'll have to talk about how I do that next time.
No worries. Just stick to the bill and tell us your story.
There's a lot of being a present father is and a mother. It's not just emotional. It's a financial responsibility that we go through. And to have your children for a weekend, you need to have safe housing, a bedroom for them to sleep in, transportation, and basic sustenance. You need to have some milk for some cereal in the morning, food in the fridge for them to eat, and the ability to have the lights on and pay for heat. And if the state removes the ability for people to afford these basics, it effectively removes that parents from that child's life. And currently, we have a disconnect between our good intentions and the math. Right now, it is possible for a non-controlling parent total obligation to for their child support, plus their mandatory health insurances, plus their child care costs to exceed 50% of their net income. And before a parent buys a loaf of bread or pays a dime for rent, the state has already allocated more than half of their take-home money to these things, and that is unsustainable. The research shows that really these numbers need to be close to 19%, and if it goes anywhere over or close to 50%, there's a huge drop-off in people actually affording and being able to pay for their child support payments and their responsibilities, and then we cause them to get into more trouble with the state. Rent consumes easily 40% of everybody's income in this state right now, and likely more than that if you live in some of these major cities like Rapid City, can be $1,800 or more for a 3-bedroom apartment in Rapid City right now. And if you live in a lower area, you might be able to get it for 14 or 15, but that still can be an average person's half of their salary right there. And that leaves 5% of money after that and a child support payment with health insurance and everything else being close to 50%, and that gives 5% for gas, utilities, food, taxes, and any maybe having some fun with your kids or playing for sports. So when we math all this stuff up, it doesn't work, and the parents can't make it work either. And so parents are losing their cars, they're losing their jobs, they're losing their self-worth and their connection, and it's causing real damage to these children. And so what we have here with Senate Bill 162 is a solution, and it's not a stop sign, it's a yield sign for our system to help these parents out. This bill amends our deviation factors to create a rebuttal presumption of hardship, that it is tough to be a parent in this world, and it's tough, everything's expensive, and it's only getting more expensive. And that the rule is simple, that the total obligation cannot exceed 50% of the obligator's net income. And currently the court can go above that and regularly does. This language in the statute is precise, that calculates this against the obligator's net income. It specifically includes those add-ons, health insurance and child care, which often are costs that break the bank. But importantly, this standard remains rebuttable. It doesn't strip the judge the authority, like we talked about before. The judge has the authority to make a difference and do something different if it makes sense. It just simply asks the judge to pause and justify why leaving a parent with less than half their income is the necessary step that's going to get the best results, because our ultimate goal is the best interest for our children. And so 50%, why is that the danger zone? Well, it looks at a timeline and it says that 50% is actually a very conservative danger zone number, when a lot of states, and some of the most successful states, like Senator Grove, mentioned earlier, California and Wisconsin, they have their orders that are set that they can't go over 20 or 30% respectively. And that with those numbers being set that low, it gives a non-custodial parent the opportunity to even maybe take a vacation with their kids or and go do something fun on a weekend, as opposed to just sitting around the house watching TV or playing in the yard. By setting our line at 50%, we're catching only the most extreme outliers of this financial cliff that we have going on. And as the compliance curve shows, you cannot get blood from a stone. When these orders are too high, payments crash. People just stop paying because they can't do it anymore. It's another bill that piles up on their table that they don't even look at because they're depressed and sad. And that's when we have people who take drastic measures. And what we don't want to have is people taking drastic measures over the ability to pay for their life and taking care of their kids. I mean, it happens too often anyways. And drastic measures, I think we can all think about what people do that are detrimental. And so we want to minimize people being in those kind of spots, being backed into a corner where they feel they have no other choices. And this is also a custody issue, and it falls back on it, but this line, it covers and allows for cross credits for shared parenting. And so we want dads and moms to share the load. We want both parents being involved in these kids' lives as much as possible. And economics is part of shared parenting. You can't use a shared parenting credit if you can't afford a house or a home to host that kid. So SB 162 ensures non-custodial parents can actually maintain a functioning second home, which is exactly what our kids need when they go to their parents' house. And like Senator Pischke got done a couple years ago, the extended parenting plan where you get to have Wednesdays and long weekends. It's important that we have that and that these kids have this access to this money and that both parents have the ability to survive and thrive. And I want to be clear, this is not about, and not a bill that does not automatically lower all child support payments. It does not remove judicial discretion. The presumption is rebuttable, and it does not excuse parents from supporting their children. It simply prevents the math from becoming impossible. And so I urge you guys to vote in favor of this today, because this bill is a triple win. It's a win. It's a pro-child bill. It ensures stability and access to two homes. It's a pro-family bill because it removes financial barriers to fatherhood and reduces conflict. And it's a pro-fiscal bill because it creates collectible orders and keeps parents employed and paying taxes rather than crushing them into the underground economy. So what we're asking today really is for fairness. We're asking for a state not to take the majority of workers' earnings without a serious look at whether that parent can actually survive on what's being left. And so today, I urge you guys to vote yes on Senate Bill 162, and let's vote for stability, fairness for our South Dakota families. Thank you.
Okay, thank you. Any other proponents in the room? Mr. Toth? Proponents in the room? Proponents online? I don't think we have any. With that, we'll go to opponents in the room.
Mr. Chair, my name is Matt Althoff. Privileged to have been appointed as Cabinet Secretary for the Department of Social Services. For the purposes of both this bill and the next bill up on your agenda, I'd like to give a little bit backstory. I also was an appointed member of the Child Support Commission, which convened this year. And that's relevant because this very issue was brought forward to the Commission for consideration by Senator Pischke and also by Mr. Martin, too. There was some public input session throughout that. Right set that's a commission that is erected every 4 years. It's charged by our federal government to make certain that you examine your schedule. But we have a great tradition here in South Dakota to say, let's look at all policy related to the ongoing child support infrastructure that's in place in our statutes. So it was chaired by a judge. That judge has had a lot of family law practice history. That judge has also served as a referee prior to being appointed to the bench. We have from the South Dakota Bar Association a family law representative that served on that. We have a representative payer. We have a representative receiver of support on that group. We have 2 legislators. Grateful to have Senator Hulse's presence on that. We learned a lot together in that commission. And also there's a referee that's on that. So I just want to emphasize why that's relevant is because there is a different bill that we hope will be in front of this committee at some point after crossover day. It's being heard in the House. It reflects all the recommendations that the Child Support Commission did take up and did recommend to the legislature, this not being one of them. What are we trying to do here? There's a reality that our federal tax code has limitations. Each child can only be claimed once on a 1040 filing. And so when 2 parents have brought that child into life, they both might want to claim it. Now that's a federal issue, but it has implications on the state side of things. So let's put that into terms. As Senator Pischke has just said, it's about $2,000, and yes, H.R. 1 does bring some inflationary elements to that tax credit. That's fact. But $2,000 as a deviation on a child support order actually is not going to be straight $2,000 of savings. That goes into a formula that we do in child support. That formula then looks at both incomes. That formula incorporates both incomes and then comes up with a schedule, which again will be updated in House Bill 1040. We hope you'll be seeing here very shortly before the end of the session. At the end of the day, and every household's different, every child support situation arrangement is different, but let me just say to this committee, this could very well be less than $1 a day. Less than $1 a day is what we're really talking about. Now, I think that's relevant because it is something that if it's just $1 a day, this could also be arranged outside of law. And in fact, we're finding that is the case. There are many situations where in the divorce order, this has been prearranged with the help of counsel. The 2 separating parents have figured out a mechanism, and we see this frequently, where they say, hey, every other year, you claim it 1 year, I'll claim it the next. And why that's relevant is because sometimes it is just better to figure it out and not let the law figure it out for you. And that's ultimately what we would say is maybe we as a commission sort of took a deep look at this and said maybe that's the better mechanism. Instead of legislating this, putting it in a statute, couldn't we just continue to observe the phenomenon where we do have many shared parenting arrangements that are being decreed, hearkening back to the previous bill's testimony? It's happening today. And couldn't we just allow that to be worked out between the 2 separated parents? Let me just say our family, or our motto, pardon me, is always stronger families, stronger communities at DSS. And we observe that ultimately is always our long-term goal. A mom is always a mom to a child. A dad is always a dad to a child. But the more that mom and dad can communicate civilly, amicably, problem solve together, regardless of where that child is at in their ongoing custody, that's in that child's interest. And so we're finding the phenomenon of working it out independent of statute and through the divorce decrees and figuring it out is a far better way. A quick note about, final note, I would just say, I sincerely, and I do want to emphasize, Senator Pischke's right. There's a justice issue here. How come she always gets to claim it, I never get to claim it? I think that's a legitimate question. Unfortunately, the arbiter of that technically is the IRS. It's written in IRS code, but there's a legitimate issue here. And so he proposed this as a simple idea. In 2001, when this legislative body enacted changes at the recommendation of a prior Child Support Commission, it did so because it found that it's not so simple to implement. This was a burdensome aspect on our referees. It requires them to look through the paperwork of 1040 filings of both parties, extensive review of that. Did they claim it? Let me see this. And that paperwork then had to be, this is always retrospective. We have till April 15th to do last year's taxes. Now I'm thinking about this current year's child support order. In that complexity, what we are also finding is that there was inconsistency across various geographic regions, which of course aligned to some of the circuit of our UGIS system. And so this is what manifested that recommendation, is that inconsistency in application. It's not so simple to implement. It's simple in concept. It very sincerely is. There's a justice issue here, but it's not so simple to implement. And that's why, many commissions prior to this past year's, this was brought forth as a recommendation. The legislative body enacted that recommendation as statute. So it can be solved today. It doesn't need statute. It is being solved in some situations today. And for these reasons, I hope you would resist this bill as brought forth, just as our Child Support Commission did in 2025 over extensive meetings. Thank you very much. I stand by for questions.
Thank you. Any other opponents in the room? Opponents in the room? If not, we do have opponents online. From Redfield?
Yes, thank you. This is Kristen Kochekian again. My concern, I'm sorry.
Nope, go ahead. You're good.
My concern is the language of the actual amendment. I think that consulting with a tax preparer to better understand the IRS code and how you can claim a child as a dependent would be more beneficial to the authors. And I would very much urge you to oppose this and vote no today, because the way it's currently written, it is not going to, I don't think, benefit what the author intended to happen. I also think it's very vague and unclear, and it's going to cause more problems than the author could probably imagine in the implementation, as the gentleman from the Department of Social Services has noted. Specifically, the amendment talks about federal income tax consequences arising from claiming the child as a dependent. Well, then the author talked about that this was supposed to be specifically for the child tax credit. Those are two different mechanisms in the IRS code. In order to claim a child as a dependent, this is going to be a situation where the child lives with one parent over half of the year, and that parent provides over half of their support. So the child tax credit can, right now under IRS code, be released to a non-custodial parent. The parents can agree to that, as the gentleman from the Department of Social Services noted. I frequently put that in my divorce or child custody and child support agreements as well, where you alternate. However, if we're meaning just the child tax credit, then that needs to be put in this bill, not the language for the dependent. Because what you're doing is, the bill does not define, number one, what consequences means. Is that referring again to the child tax credit, to the earned income credit, which is not available to a non-custodial parent because of the support and the living with the parent rules? Are we talking about the head of household status, phase outs, filing status implications? And what you're doing is you're asking the court to calculate either actual or hypothetical tax returns, as previously noted. So this is going to be a nightmare across the board for the child support referees and the court. It's also duplicating statutory mechanisms that already exist. If you look at SDCL 25-7 6.18, there is already a mechanism that allows for a percentage adjustment when the custodial parent claims the child tax credit for dependent and daycare expenses. So you're going to have redundancy now. You're going to have relitigation of what's already been handled statutorily if someone gets this 7-6.18 percentage adjustment, and it's going to undermine the coherence of the existing child support framework. Right now, at present, I noted the child tax credit can be released per federal law. But number one, this is a decision made between the parties and their tax preparers, and it's also subject to whether federal law will change in the future. So certain credits like the earned income credit are structurally specifically to benefit a custodial household. That is the purpose of those credits, because that primary parent provides the majority of the utilities, of the housing, of the food, of maintaining that child's general welfare. If a deviation is used to compensate the non-custodial parent for losing tax benefits that federal law intentionally assigned to the custodial parent, the court is effectively undermining the policy rationale of the federal credit and also reducing resources that are available to the child's primary residence in order to support the best interest of that child. So the deviation, the idea behind it may come from a good place, but ultimately this bill should be voted no on today because the bill language before this panel is not appropriate. And again, it's going to cause some real issues for the children and the best interest of the children. Generally, child support exists to meet the child's needs and reflect parental resources, and it shouldn't function as a mechanism to equalize tax outcomes between adults. Deviation factors traditionally focus on hardship, special needs, and equity between households that serves the best interest of the child. But based on just looking at the parent's tax position and what the statutory mechanisms that we already have, what federal law allows a parent to claim, I just don't think that this bill is appropriate to be passed, and I ask you to vote no.
Thank you. I think we have one more proponent online. Terry Williams out of Rapid.
Can you? Good morning.
Okay, there you are. Yep, go ahead, tell us your name, where you're from, and you give us your testimony.
Thank you. Sorry. Yes, thank you. And thank you, Mr. Chair. And I apologize that people couldn't tell that I was on before. I realized that I had discontinued my caller ID. I oppose SB 162 on the basis as stated by Ms. Kochekian. The child support referees, which I have acted as one in the past, have approximately half an hour of time with these hearings, and they are the ones that are armed with trying to determine child support and then send that to the courts to then have the court approve or hear objections to the recommendation of the referee. This will become exceptionally cumbersome to add this particular provision to the deviation factors, as stated by the Department of Social Services gentleman that testified, and again, as Ms. Kochekian has already testified. More importantly, as Ms. Kochekian indicated, this is very confusing as to what Senator Pischke is actually requesting of this bill. There are already mechanisms to allow for tax consequences, i.e. tax benefit, to one parent to be considered when considering child support. This will actually muddy the water, in my view, and not assist whatsoever. Therefore, I request that you vote no on this particular bill. Thank you.
All right, thank you. That ends our opponent testimony. One more time in the room, opponents, in case anyone walked in. Hearing none, we're going to stop we're going to give you time for rebuttal.
Thank you, Mr. Chair, members of the committee. Senator Tom Pischke, District 25, before you get in for rebuttal. Just a couple of things here. I appreciate the kind words of Secretary Althoff and things he said there. The problem here is that not everybody has this written into the divorce decree. And so if you don't have this written in your divorce decree, essentially you would have to go back to the court and ask for them to put this back into your decree. So think about what that takes. That's going to take an attorney, retainers, and going through that whole motion to get that done. He talked about this being $1 a day. I suppose if you broke down the scenario where it's only one child, so it's like, let's just imagine it's a $2,000 tax credit, one child, and the income split is like an 80-20. I suppose you could imagine it's only $1 a day at that point. But most child support obligations, most parents are making a decent income, and they're closer to a 60-40 or a 50-50 in somewhere that aspect. And so for one child, it's going to be closer to $1,000. And again, remember there's an inflation aspect to the child tax credit too. So more often than not, it's going to be a higher amount. And then you have more children. If you have 3 children, for like my case, you're talking over $6,000. And if your incomes that are split more like I have, that's going to be $3,000. That's going to be factored into that calculation. So it's not necessarily just $1 a day. And so I would just put that out there. In regards to some of the other opponents' testimony, if you look at 2576.18, that's talking about child care credits. That's not what I'm talking about in the child tax credit. Child care credits is something completely different in code. So I think we need to keep our eye on the ball here and bring it back to what I'm talking about. So that's not even what I'm referring to here. So there's one more thing. I guess, this is something that we did prior to 2004. I brought back the same exact language that was in the code. And if we're having trouble, if child support referees are having trouble applying it equally across the board, I would submit to you that judicial training would be the solution. The judicial branch of our government can provide training to the child support referees and tell them this is how we want this to apply. And so that's what I would submit to you as a solution if we did implement this back into code. And so I would encourage you to vote yes on this. Thank you.
Thank you. With that, we'll close public testimony. We will go to committee questions. Are there any questions? Senator Grove.
I'm not quite sure if this is for you or for the secretary, and maybe you just kind of answered it and I'm missing it, but when you do your child support and you want to increase child support or the other person wants to decrease child support, you can hire the child support referee in the state of South Dakota, and it's like really super affordable and amazing. In that process, can't those referees, if you do what you just said and it's not added into your divorce decree in the beginning, can't they add it in as the child support referee at that time that you're switching years? This year you get the child, that next year this X gets it? Isn't that part of what they do?
Mr. Chair, do you want me to answer from here or from?
You go ahead. You're good.
You can have Secretary Althoff to come up as well, but no, that's not. If it's not in your decree, you don't get that tax credit. So, and you are right. It's free to go have your child support modified every 3 years. But unfortunately, no. If you don't have it in your decree and you don't have this in the law, you don't get any credit to the child tax credit as of right now.
Mr. Althoff.
Mr. Chair, Matt Althoff, Secretary DSS. As has already been alluded, I'll just extrapolate from there. Yes, you can go access it. It is every 3. There are also other events that will trigger your ability to go ask for the order to be revisited. There is discretion, so there are provisions in that this actually could be factored and considered into it. That we would say on the facts and circumstances of that particular child support order, there is the privilege of the referee to kind of work through that case by case.
Mr. Chair.
Yes.
So are you saying that depending upon whatever issue they're trying to figure out, an increase or a decrease, and the one parent says, hey, why aren't we sharing these tax write-offs or whatever, are you saying that at that time it can be by the referee added?
Mr. Chair, let's be mindful, what this law would do is give the referee the force of law to compel that. What happens today is it's sort of a, let's talk about how this is being treated on the respective tax returns. There's a discussion that's had. That's what the referee is going to facilitate. That referee does not have the ability to compel somebody to change their filing, but it is something that is absolutely on the list of possible deviations that can absolutely be considered when looking to revise an order.
Any other questions? If not, we're going to move to action. Do we have any action on Senate Bill 162? Discussion, I'm sorry, discussion and/or action.
Mr. Chair.
Oh, you bet.
Thank you. I guess this would be for Senator Pischke. Can you tell me what's the average monthly amount of child support? Do you have any of those numbers, or?
I'm going to, if you don't want to answer that, I mean, that gets pretty confidential, and I'm not sure it's germane to the bill, because the credit would be a fixed credit on a federal level, not necessarily tied to that, but you go ahead.
Mr. Chair, I won't answer personally. So I can't really tell you, but the way child support is calculated is that you put in both parents' incomes, and it goes into a calculator that figures out a certain amount based on both parents' incomes, and you add those together, a percentage for the payer, the percentage for the receiver, and then it's all calculated. And then there's certain deviations that can come out of that as well. So it is pretty complicated. I'm not going to try to go into every aspect of it right now. And so to give you an average, the department might know that number. I'm not going to try to guess what that number is. What this bill for you is to give you another thing, another factor that could be considered as a deviation. That's what the bill is before you, and it goes back to the federal tax credit.
Sure.
Thank you, Senator Pischke. Just for the record, I wasn't asking a personal monthly amount. I would just somebody's got to have, that's got to be public knowledge on what the average would be. Another question, please. Yes. How often does support exceed 50%?
Mr. Chair, I'll try to answer that. So there is a cap in South Dakota law that it cannot exceed 50% of your income. If it does calculate that it is over 50%, it'll bring it, the child support referee is supposed to bring it down to that 50%. So that's supposed to be the cap. And I've been at that cap before, and it's hard to make ends meet. I'll tell you that. I work in 3 jobs.
Thank you, Senator. Comment, Mr. Chair?
Yes. Discussion?
I just pulled up 25-7-62, and it looks like for an income of $3,000, it would be, for 2 children, would be about $1,100. So that, and it seems incremental, $4,000, it would be $1,340. So it looks like it's about average, seems like it's 25%, 25 to 30% as an average. Thank you.
Thank you. All right, any other discussion? If not, we'll close discussion and move to action. Action on Senate Bill 162.
Mr. Chair.
Senator Duhamel.
I move to the 41st day.
Second.
We have a motion from Senator Duhamel, second from Senator Melhoff. Move to the 41st day. Discussion on your motion.
Simply, the commission worked hard. They were the summer study. They dug into this and rejected this notion. And it sounds like it'd be difficult to impossible to implement for these referees. Thank you.
Any other discussion? Senator Grove?
So I understand what she's saying. This is different, but I guess I think that it is a topic that we should consider in the future, where referees are able to just simply add this opportunity or option to a decree. I mean, they're working on financial things. I don't know that they have to get into all the numbers, but I don't understand why they can't just say, we're adding this and you guys are going to start sharing this tax write-off. Anyway, that's my thought.
Senator Hulse.
Thank you, Mr. Chair. I struggle with this bill and probably the other bills that are going to come forward as the sole member of this committee that actually served on the commission this summer. I think that, there are a couple different topics in this area that really do need to be looked at. And from my understanding, tax credits were considered in the past. And especially now that the tax credit has significantly gone up, I think it is worth discussing because now it has been tied to CPI, which means that there isn't going to be hopefully significant changes to this policy. And that was the reason historically why this went away, was because it kept changing. And so that was making it difficult. And so I can understand why it went away originally, because it was on again and off again and on again and off again. And that made consistency difficult. Now, that's not necessarily something that we hope to see in the future. I don't know if necessarily this is the perfect way to do this, but I am in support of the idea of what we're trying to do here. And so for that reason, I'm going to resist this motion.
Any other comments? I'll just mention, I think, one, this is probably on this bill as a house of cards, and I think the card is at the bottom. And two, I have a hard time, and I hope not to prejudice myself against the next bill, but going against the committee in all of those meetings is hard, just because of a personal, when we do summer studies and things like that. So I think that the work that's done is good, and it's really hard for me to just go against all of that information. With that, Secretary, please call the roll.
Senator Blanc.
Pass.
Duhamel.
Aye.
Grove.
Aye.
Melhoff.
Aye.
Pischke. No. Blanc.
No.
Hulse.
No.
Colbeck.
Aye.
Mr. Chairman, we have 4 ayes, 3 nays.
Having received an affirmative vote to send to the 41st day, Senate Bill 162 is declared dead. All right. We're going to move on to Senate Bill 163. It's going to repeal provisions related to the shared parenting child support cross credit. Senator Pischke.
Thank you, Mr. Chair and members of the committee. Again, Senator Tom Pischke from Del Rapids, District 25. Before we get going, I would like the committee to amend my bill. 163B is really the language that I want to present here today.
And it is published?
I
see it out there.
163B.
Yep. B as in boy. Do I have a motion?
Mr. Chair, I make a motion to amend to 163B as in boy.
Second.
And a second by, so we have a motion by Grove, second by Melhoff to amend 163B. Discussions on your motion? Sounds good. All in favor say aye.
Aye.
Opposed? We're now on your amended bill.
Okay, thank you so much, Mr. Chairman and members of the committee. I appreciate that. So in essence, what we're trying to do here with 163B is right now the idea to get to the shared parenting calculator is you have to have 180 overnights. That's a very high standard. If you think about that, if you have shared parenting, you have to have basically every other night. And so many other states have moved away from that very high standard. We're actually at the very top of that. And we'll have other proponents that come and talk to that as well. So what this bill does is puts that at 120 nights to qualify for the shared parenting plan, and then also removes the 1.5 multiplier in how the cross credit is calculated. So as Senator Blanc talked about in the previous bill, when you look at all those calculations, the obligations in the table, when you're into this shared parenting calculator, it would take every one of those obligations in the table and multiply it times 1.5. And so I think that's a very unfair way to calculate child support, especially when you're in a shared parenting arrangement. It's really a deterrent from wanting to do shared parenting, quite frankly, because if you did the shared parenting, and now you're going to have to pay an even higher obligation. So I think that if you're in shared parenting, you're already taking care of your kids and providing for them when they're at your home. And so I don't think there's any need to to multiply the obligation by 1.5% or 1.5. So, I mean, obviously, if you think about that, that's a 50% higher in the obligation. So that's basically the gist of the bill, and I'll stand by for questions.
Sounds good. Any other proponents? Senate Bill 163. Good. We are a little tight on time. We've got to free our committee room, so we'll keep it tight.
I'll try not to ramble. Chairman, committee, thank you again for letting me talk today. Here for the same goal, we want to help out families in our community.
Say your name.
Oh, excuse me, I apologize. Zach Martin, I will get that right next time. We're here to help out families and help families going through the situations. And we want our children to be provided for, safe, and loved by everybody. Right now, National Parents Organization, who spoke earlier, gave our state an F+ on our child support policies. And this is a huge part of why they gave us an F+ is how we calculate how we declare child support. SB 163 is the fix. It is a data-driven, evidence-based reform that does exactly what the title of this presentation talks about, and I gave you guys the slides on it, Stronger Families, Stronger South Dakota. It builds stronger families and removes the barriers that keeps parents and children away. So under current law, a parent is treated as a visitor until they hit 180 days, which is half, or so close. But at 179 days, it's all the payment is all based on the visiting parent's time, and only at the 180th day do you cross over that cliff and actually make it where both parents are counted. So a father who cares for his kids 170 nights almost at the time gets no credit for the support formula for the time that he has the kids and gives them food, housing, transportation, anything else that they go and do. He gets no credit for that in our current setup. And that's a massive cliff. And it's an incentive to keep fighting going because it incentivizes the parent who has the control to use that control to minimize the amount of time that that parent has. And the parent who has control is incentivized to not allow the other parent to be equally involved with their kids. SB 163 fixes this, and I think, and Tom and I have talked about it, I think that it's still too high. 120 nights, that's about 33%. It's still too high of a number. The average now of most of the states is 25%, and we have states that are even down to 19%, but where we are currently is the top. We are the most restrictive and punishing state for what it takes to be both parents' incomes being to be calculated. So this somewhat aligns and still falls behind the national averages and recognizes the simple truth that we are caring for our children and that we're not just visitors, that we are parents also who want to be there. Lowering the cliff will lower conflict and will let parents focus on parenting rather than litigating over who gets to have what time and how much time they get. And the other issue with this bill is the multiplier. And currently, our parents share a multiplier of 1.5 multiplier, which is like 1.5 times the amount that both parents make. And I think an easy way to do this is that we take this amount of money that people make, right? And we put it down there, and then we divide it all up. And then we assume, though, when we divide it up, that they're actually making half more. So if you look at like a pie of pizza, we make a pie of pizza. This is what they actually have. But then we assume, actually, we have this much pie, which is 1.5 times. So, and then you've already divided. You're dividing it up off that 1.5 times. But the actual pie you have is a third of that, or 2/3 of the actual size. And so you actually have a much smaller amount of money you're playing with, but you're dividing it up based on you having a number that's not actually real, that nobody has. And so you're really hamstringing the parent who is been chosen to be the non-custodial parent. And usually it's not by their choice. It's been dictated to them that they are the non-custodial parent. And so the theory is that 2 homes cost more, but in practice, the inflation factors push orders beyond that, and parents aren't able to make up with it. I think Tom Pischke said he had 3 jobs to be able to support himself and take care of his kids. And if you're that stressed out, how can you be the best dad and parent you can be for your kids when you're working that hard? This would actually reduce that amount, and it would make it so we are basing our child support payments on the amount of money that parents actually make, and it actually is used to help support these kids so they can have a quality of life with both houses. And just some research on it. The Urban Institute found that child support, when it takes more than 19 to 30%, compliance drops off significantly. So then we have more court issues. We have more people going to jail for not paying their child support. We're taking more licenses away from people, hunting licenses, professional licenses, when they can't afford to pay these these high numbers. And if somebody lost a job, which, we're having an interesting situation with AI and stuff going on around the world, that people are going to be losing jobs. And it's going to have a negative impact on people's ability to function and make money, and that those things are going to come back, and it's going to hurt these people. And there is no grace for anybody who doesn't have a job to be able to pay these things. We're still out there punishing them like they are able to make it. And this order is going to, or this bill, excuse me, is taking too long to do this. And we have imputed numbers and incomes to parents who physically cannot earn that money. And if a parent is incarcerated or disabled, our current system often pretends that they are working full-time and charges them accordingly. They pile up thousands of dollars in debt while they're behind bars, and the debt that they could never pay off. And when they get out, it destroys their credit, and they still can't afford it. And so then we just have people who are now they're in the black market doing other things, not working traditional jobs or working at all. And how is that helping our kids? Okay, and I can do more. Thank you, guys.
Mr. Martin.
Appreciate you guys. Thank you.
Any other proponents in the room? Senate Bill 163, proponents? Do we have any online? I don't think so. No. No proponents online. With that, we'll move to opponents. Mr. Altoff.
Mr. Chair, thank you. Again, Matt Althoff. I beg of the committee to hearken back a little bit to every 4 years the Winter Olympics comes along, but in DSS it's the Child Support Commission. So in that, we're having a little bit of deja vu, frankly, in this moment as we try to cram together a couple of talking points. And I would just want to emphasize characterizing, you said summer study, it is not that, but it reflects it very similarly. Multidisciplinary group. We met 6 times, including taking a pause where we received over 120 written comments. We said 60 days, please give us feedback. We reconvened. In the September meeting, and I should characterize, our meetings are 4 hours long. We leave open, they're open, they're leave room for open testimony. Senator Pischke was very kind to hang in there with us and offered oral contributions every one of these meetings. The September meeting comes along and we're trying to drive it. We got to bring a recommendation to it, and this very concept was brought up very late in the game. And I would emphasize there are some real issues with cross-credit deviations. There's real economics behind the 1.5. It's been demonstrated economically that when you have a child living in 2 households, it just costs more money to raise that child. You have multiple beds, you have multiple staples in your refrigerators. There's just a lot of other things that get incurred from the 2 households. And remember, child support is always looking at an imaginary element of these 2 wage earners. The parents are living under one roof. That's how the child support formula works. We know they're not, but that's how you make these calculations. But it didn't factor the abatements. And so if I may, I want to harken back to the good chair's comment earlier, the house of cards. This is it. To undo this on the cross-credit deviation without factoring for the abatements, the Child Support Commission said there's something there, but we got to think through all the ripples. We got to think through the ramifications. And in that same, the proceedings that we had in that September meeting, I remember vividly, oh, by the way, Wyoming just did this. Well, that's attractive to somebody who sits on that commission at the appointment of the governor, because if a neighboring state has enacted a comprehensive revision to the cross-credit deviations in addition to the abatements, we should study that. What's happening? They did their best to contemplate the ripples, the ramifications. Let's see how well they did calculate that. What are the implications? What's bearing out in that process? And so we as a commission did recommend this bill, but in the form of, to the next Child Support Commission, take this up in earnest. Let it be your first agenda item. In charge the department to come with a lot of data. When you reconvene, study this issue in its multiple ripples and its its parallel to this, the abatement phenomenon, and then come back with a lot more data to inform the commission that our subsequent commission would take this up, not on the very last meeting before we're trying to set a recommendation, but instead at the very beginning. And I sincerely appreciated my opportunity to talk about that with Senator Pischke. I think it might have been a detail missed. Totally understand that when you're in an open meeting, you're participating remotely and those sorts of things, but that was a very earnest recommendation incorporated in our report that was delivered to Governor Roden and Chief Justice Jensen, as well as to the LRC staff. Start here the next time the Child Support Commission convenes. So I'm staying away given the limitation of time, Senator Colbeck. I would respectfully say that there are a lot of concerns that we would say, but I'm not here to counterpoint. I just want to say I think that's the better solution as we all are learning. Child support is a labyrinth of our statute. It is a lot of very special people that dedicate a lot of their professional times to sort of work through that, and it can be a little bit of a foreign language to a lot of us that are sort of lay to that space. So that's why I'm staying out of the technicals, Senator Colbeck, respectful of time. I'll stand by for questions.
Thank you. And we have another opponent, Ms. Kitchkan from Redfield.
Thank you. I would defer to the gentleman from the state. I think he covered all of the points and concerns I had.
Excellent. Thank you. And then our last opponent, Ms. Williams from Rapid. We'll keep it laser focused here. If you want to give us a Me Too.
Good morning, Mr. Chair. Terry Williams. I am indicating to the committee as a whole, requesting that you please do not pass SB 163B, excuse me. Again, as a previous referee practicing family law for over 30 years, as was stated by the Secretary of DSS, that the statutes concerning child support are cumbersome and they are all intertwined. This proposal leaves many questions. If you delete the cross credit and you have a shared parenting, there is no indication then of whether you apply the abatement, and how do you apply the abatement if you don't have a primary custodial parent. It doesn't, right now, it doesn't make sense. So I very much appreciate what was stated by the Department of Social Services, that there needs to be some time to review and look at how to modify the child support statutes to address whether or not the child support cross credit and the implementation of the 1.5 need to be modified for families that have shared parenting. There are different calculations dependent upon what type of parenting plan exists. And as was stated, the shared parenting cross credit multiplier, let me rephrase that, the shared parenting multiplier is in place because of the proposition that if you have two active households, not one active household, that you've now increased both families of trying to provide for their child. So by removing that 1.5, you are going to impact one of the parents, and that one parent that is going to be impacted is the lower wage earner, whichever parent that may be. And then next, again, if you don't have the shared parenting cross credit, but you're trying to allow for a deviation, how is the referee or the court supposed to apply that deviation when you don't have a primary custodial parent? Neither parent is primary. They're exercising shared. So it doesn't work. Finally, I want to make a comment that was stated that we need to have this because of the disparity that's involved in child support. Just for educational purposes, when persons are jailed for 6 months or more, they do not pay child support. They get a zero order. And that is part of what will be presented, what has been presented the last 4 years, and I think is again in the bill with the House bill. So with that, I urge a no. Thank you.
Thank you. And that'll close our opponent testimony. So we'll have time for rebuttal, discussion, and questions.
Thank you, Mr. Chair and members of the committee. Again, Senator Tom Pischke from Del Rapids, District 25. Just want to say a few things. I kind of see where this is heading and can read the room. But I've been a part of the legislature now 10 years, been a part of the back end of the 2016 Child Support Commission, and had to deal with the repercussions of the decisions they made and fought some of their decisions in the legislature. was part of the 2021, well, wanted to be on the 2021 commission, was basically ignored by the governor and wasn't able to be on it, but participated in all the meetings. Same thing again for the last commission, and participated in all the meetings, gave my input. And maybe, just maybe, I'm finally getting through and they're recommending one of my ideas. You know, I've been on the forefront of trying to reform this system for many years now. And it's frustrating, and maybe we're getting there, but it's frustrating because the system, they will argue that it's based on the child and providing for the child, but it really tries to maximize the amount of dollars that you can get out of the non-custodial parent. And it's frustrating because, to me, we should be trying to maximize and focus on the most important thing, which is the child-parent relationship. The child support system, in my humble opinion, doesn't focus on that. It focuses on basically maximizing that financial incentive. And if you look, there's other reasons as to why that is. I mean, we get money from the federal government, part of Title IV, Part D, and how that all works. And I'm not going to dive into those details because, again, I know where this is going. But there's more to this. And I hope and pray that in the future that this commission will try to include me in a more inclusive role, actually being part of the committee, because I've wanted to be part of this commission for many years now. And I hope they start looking at this as more of a making sure that the single parents stay off government assistance, because that's the intent, right? We should have enough support that they stay off government assistance, but we shouldn't be incentivizing divorce. We shouldn't be incentivizing single parents. We should be incentivizing just that the child's needs are taken care of, but yet the child-parent relationship is cared for. So I'll leave you with that to think about into the future, and that's really where my aspect always comes from on all these bills. That's the most important thing to me, and so I'll just leave you with that. Thank you, Mr. Chairman.
Excellent. Thank you. With that, we'll close committee public testimony. We'll go to committee questions. If no questions, we'll move to committee action. Do we have any action on Senate Bill 163?
Mr. Chair, I'd move 41st day.
I have a motion from Senator Melhoff, second from Senator Duhamel to move to the 41st day. Discussion on your motion.
Thank you, Mr. Chair. These are always difficult bills to take up. They have a lot of moving parts in them. And I know that a commission really spends a lot of time considering these issues, and I'm just not comfortable second-guessing the work they've done after a 30-minute hearing in a legislative committee. So first rule is do no harm.
Any other discussion? I would just briefly mention that I think Senator Pischke is right. There's a problem. Senate Bill 162 demonstrates a problem. Senate Bill 163 demonstrates a problem. I think what we disagree on is how we get to this solution. And that's, again, I have a hard time going against all of those meetings and all that testimony, not having the data. So I would make that. You want to make a comment?
I do. I just want to say that I think he's, all three bills point out that we have an issue, and I think that he should be in those hearings, and he should have a voice. And since he hasn't had, I would love to see some kind of a task force this summer address these three issues. I think there are better ways that we can be handling our child custody situations, and I just applaud him for his dedication and his heart and passion for this subject. And sadly, I'm going to have to vote against this bill, but I am with you.
Senator Hulse.
I just want to say that serving on the commission was an education. I don't work in family law, and I knew very little about the family law process until serving on the commission, and it, like I said, was an education. I will say that, as we all know, even here today, there wasn't a lot of public testimony, even when we're hearing some of these bills, and especially during the summer. I wish that there would have been more public testimony from both sides, the payee and the payor, to hear about some of the issues. But sadly, the public doesn't pay attention very much to summer commissions. And so for anyone listening to this testimony, I hope that you hear this and do participate when we have that commission 4 years from now. And sadly, it does only happen every 4 years. But it was my experience that there was not, and as someone who was new to the process and new to the system, it was kind of hard for me to take certain stances or to understand really what was going on, because the data is very dense, and with the lack of testimony from more than just basically the people that are already here in this room, it was pretty difficult to decide some of these policies. And I think that process could be better improved to include more public testimony or more testimony from the people that this really impacts, not just people in their ivory towers from, with doctorate degrees and that are the referees. So.
Okay, and Senator Blanc, wrap it up.
Very briefly, I too want to commend Senator Pischke for not giving up on what is on his heart and who he wants to see represented accurately. Just want to say I agree with what Senator Grove said. Great comments.
All right, with that, we have a motion from Senator Melhoff, second from Senator Duhamel to send this bill to the 41st day. A yes vote will send it to the 41st day. Secretary, please call the roll.
Senator Blanc.
Aye.
Duhamel.
Aye.
Grove. Aye. Melhoff.
Aye.
Pischke. No. Hulse.
No.
Colbeck.
Yes.
Mr. Chairman, we have 5 ayes, 2 nays.
Having received an affirmative vote, 41st day motion passes. With that, we are going to defer Senate Bill 159 to Thursday. We will hear that first on Thursday. Thank you for your time. With that, I'll take a motion to adjourn. So moved. Motion and second. All in favor say aye. Aye. We are adjourned.
SDPB celebrates South Dakota's student athletes with live coverage of SDHSAA state championships, sharing the excitement of hometown heroes. SDPB, good, useful, and full of wonder.